getting fined by regulators, advisors. It's a litigious society that we deal with, and advisors have to deal with not only clients, but their firms themselves. I recently remember an article that I saw, does a firm have an advisor's back? And I think the clear answer is a firm absolutely can have an advisor's back as long as their interests are aligned. And as soon as those interests no longer are aligned, then clearly what we've seen in the industry is firms actually won't have an advisor's back. And Scott, I'd love to have you maybe I know you have the opportunity to protect and work with advisors in a lot of these scenarios. And I'd love to have you kind of weigh in on what you've seen in the marketplace and seen from advisors as it relates to how to avoid some legal troubles and whether firms really do have their back.
Well, sure, Jeff, and I'm happy to do that. I can tell you, I represent a lot of advisors who are either facing the threat of termination or who have been terminated. And and I read that same article you're referencing, and I can tell you that firms only have advisors' backs as long as they are useful and profitable to them. And the minute that they're not, they won't hesitate to throw an advisor under the bus. Sometimes for the most ridiculous of reasons. I mean, years ago, I represented an advisor at Edward Jones who was terminated allegedly for not paying for his sandwich in the company cafeteria, that he didn't swipe his key card, make sure it got taken off of his debit account from his meal plan. So that gives you the sense of how petty firms can be when they terminate. Well, one thing I can certainly tell you is, unfortunately, a lot of advisors come to me after they've been terminated or when they are on the brink of termination. And as I get into it, I find out that they were questioned, interrogated, perhaps weeks or months earlier by an internal investigations unit at their firm, and didn't do anything about it, and thought that the problem had blown over. And I really cannot say this strongly enough. There is no such thing as just a friendly chat with compliance. And if an advisor has been summoned to an interview with an in-house lawyer or an in-house compliance person or an in-house investigator, they should assume that they have a target on their back. It does not mean necessarily that they will be terminated, but they need to start planning for the possibility of termination and not sit there in denial and hope that the whole problem will just blow over, because it does not happen.
Yeah, and I think what you're referring to is clearly a normal audit, which happens, annually, and in some cases even multiple times a year, is a normal course of doing business. But separate from an audit, when they're calling you in for an interview, there's something that is amiss. And what we see, is there's a much more of a shoot first, ask questions later, let's just protect the firm at all cost, I think, approach to some of these happenings.
That's absolutely the case. Firms will often just terminate an advisor if there's something that they are concerned about, regardless of whether or not they've reached a conclusion that the advisor did something wrong. The firms are ultimately concerned, number one, with risk avoidance and risk management from their standpoint, and they would much rather just fire an advisor about whom they have questions. It's easier to do that than it is to try to dig into things and determine whether or not, in fact, their suspicions were misplaced. And that is often the case, that advisors get fired and then have their U5s marked up after termination, without the firm really having reached a reasonable conclusion on those findings.
Yeah, and I think what we should kind of qualify for the listeners out there is, look, there's a lot of different aspects of legal, right? There's terminations, there's customer complaints, there's, outside business activities, and there's also when you leave your firm, right? We spent the first podcast or two talking about leaving the firm, so we may not spend any time on that for this one, but everything from interacting with outside business activities to client complaints, all of these things can lead to some legal obstacles, legal challenges, and can put advisors into some jeopardy if they're not careful. I mean, I know I've heard of advisors who have complained about, literally working with an outside business activity and that coming back to bite them. Maybe you could spend a couple minutes just talking about some of the different categories that you've seen.
Sure. Undisclosed OBAs or allegedly undisclosed OBAs is certainly one category. Uh, a I've seen advisors terminated for customer complaints that didn't really have a basis in fact. Again, it's just a matter of the firm is taking a guilty until proven innocent approach. But I've also seen advisors terminated for just being general malcontents and speaking up about things that they think are wrong at the firm. Um, and and then the firm manufactures an excuse to terminate the person and try to separate them from their book. And that often comes up in the context of partnership disputes where they just decide that they're gonna take sides with one advisor over another, and it's easier to just terminate one of the advisors and consolidate the book with the more senior person usually. Unfortunately, a lot of the time, termination is driven as much by office politics and business considerations, more so than actual basis or merit for doing so.
And so what do you do, right? Is there a way to protect yourself from this stuff?
Well, yes. I mean, frankly, taking detailed notes after any such meeting or interaction with legal or compliance about who said what to whom, or following up with an email afterwards saying, following up on the meeting we just had this morning, you accused me of A, B, and C. Uh, this is not true because of one, two, and three, and here's the documentation to prove it. And if you paper the file, so to speak, and demonstrate that there is a lack of merit to the allegations against you, it will often cause the firm to think twice about terminating you. Frankly, the other thing you can do, and it's not a matter of a pitch for business for me, but for anybody, is hire qualified counsel who can coach you from behind the scenes. If you're going to be summoned in for another interview, or if you've gotten a notice that you're going to be called in for an interview, hire a lawyer. They can help coach you about how to handle that testimony, about what to say and how to say it. But really, it comes down to documenting, and documenting, so that you have created a record of the fact that they are out to get you, and that there's no basis for them doing so.
Should you leave the firm in kind of in anticipation of some stuff happening here, right? So if you get called in while the investigation is going on, do you leave the firm in the middle of it?
I would say you have to depends on a case by case basis about the tone and tenor and the direction that the investigation is going. But what you definitely should be doing is at least exploring your options. You need to have somewhere to go in case things go south. But oftentimes, again, when one is terminated, the advisor then gets a black mark on their U5, and it will make it harder to leave. So I would say if an advisor feels that termination is imminent or likely, yes, then you pull the escape cord and get out and get to a new firm before that U5 gets filed. But I don't know that you necessarily have to overreact and panic, but you have to be proactive rather than reactive in addressing the situation. And again, it comes back to not being in a state of denial and pretending that the problem is just going to go away if you ignore it.
Yeah, I've often wondered, right? Do firms actually mark someone up who leaves in the middle of an investigation, and we never know if the investigation how it would play out, right? So it's a predicting the future kind of thing. But does a firm mark somebody up and say, hey, they left while being under investigation, and now so they get marked up even if they were leaving on their own in advance of the investigation being closed out?
Yes, Jeff, they absolutely do. There's a spot on the Form U5 that the firm will check, that indicates that the advisor resigned while under internal review for potential violation of firm policies or procedures or industry rules or standards of conduct. So, you're at least marked as voluntary on the U5 that you resigned under your own power rather than being terminated. But if you leave in the midst of an internal review into your activity, the firm will disclose that on the U5.
Do you happen to see that more from W-2 firms versus 1099 firms, or is just there's no rhyme or reason to that one? Because it kind of lets the firms off the hook is the way I think about it. They don't even have to finish the U5. They don't have to finish the investigation. They can then mark somebody up in any event and still try to retain some of the business, which, again, in the W-2 world, if a lot more firms are trying to retain that business versus the 1099. So I'm wondering if you see a trend or it really doesn't matter on that side of it.
No, I think it's egalitarian on that point, Jeff, and they actually do have to complete the investigation. There's another field on the U5 that once the investigation, and it's really not an investigation, capital I, it's an internal review, small I. Once that
Yep.
review is completed, they're obligated at a later date to file an amendment to the U5, indicating that the internal review is complete and what their findings were.
Okay.
So the firms will do this one way or the other, not even in the independent space where they're not using it as a wedge to try to retain business, but because they've got reporting obligations to FINRA, that if they think that an advisor has a red flag, they are going to bend over backwards to report that to FINRA, because they're more worried about FINRA coming back at them for not letting them know that there was an issue. They'd rather upset the advisor than upset FINRA. So they err on the side of sort of oversharing with FINRA on this stuff.
Yeah, I appreciate you sharing that. That's actually insightful for me, as I didn't realize that they still have to close out those investigations. Pivoting a little bit, and we think about this stuff. One of the things that I've seen is advisors joining firms and firms saying, "Sure, no problem. You can do this type of a business or this type of an outside business activity, or you can do X, Y, or Z." And then but that event is, I'll call it gray, and later get the advisor in trouble, right? And while firms, I've always experienced, kind of are in the mindset of firms they'll get fined and advisors can get put out of business. That's the expression I've always used, right? And I'm not the attorney, clearly. Is there any merit to how I think about that and how I describe that? Just to kind of level setting for folks out there, be careful of what a firm may let you do, because just because they let you do it doesn't mean it's allowed, and it could still get you into trouble.
Well, I think it's well, yes, there is a lot of merit to that, and in fact, I'm dealing with a situation like that right now where a client disclosed an OBA to the firm a couple of years ago. It was vetted and approved by the firm, but they've claimed that the nature and scope of the OBA changed over time. It broadened and modified, and that the advisor did not properly disclose to the firm those changes. My client obviously says it's all part and parcel of the same general approved conduct, and you can't reasonably expect me to update the firm every time I'm doing something that's a little bit different within the scope of the more general OBA. And the firm took a very different position and used that excuse to terminate my client, and presumably now will try to use that bad PR to make a play for his book. So, my advice is that advisors should always, if there's any meaningful change to the scope of their OBA activities, that they ought to be updating the firm on a regular basis, and making sure that they are getting approval all along the way to immunize themselves from problems.
And kind of the last category I see is that advisor to client relationship. A lot of the clients, a lot of times an advisor will meet with the client, and they'll just, after the meeting, even though a client has been there for a long time, after one particular meeting, they just can tell it, "Hey, that wasn't a great meeting." Do they do anything different after that meeting? I would assume document, 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 but are there other things they can do, kind of ongoing with those client meetings that are happening that are normal meetings, as well as those that may just don't go as well as the client challenges you or is concerned about something? What do you say to those advisors?
Well, I think with those advisors, again, not ignoring the problem, and this is a good time for you to enlist the assistance of your branch manager or your compliance person in your branch, to say, I just had a meeting with a client and it didn't go as well. I've got a little bit of a funny feeling about it. I haven't done anything wrong, but here's what's occurred. This is where the firm can actually help you, right? Um, because the last thing they want is to be surprised with a customer complaint down the road. And telling them, look, the customer didn't complain about anything, but I just sort of feel uneasy, and enlist the assistance of management to help you smooth it over, or figure out how to be proactive about addressing the situation. But again, Jeff, to your point, absolutely. Document is always the key provision there. And following up with the client to see if there's anything else after a couple of days of reflection, if there's anything else you can do to address their concerns.
I think that's a great idea of using kind of going to the compliance or the management for advisors. I mean, so often advisors are, I don't know if the word is afraid, but intimidated and just want to avoid it, right? And they kind of put kind of bury it as much as they can and pretend it didn't happen. And I think that's a great example of when you should be proactive in utilizing folks. And for those advisors who have, there's clearly going to be advisors who may not have the best relationships with their management, and they're going to be concerned about that. But I still think it's an example where they need to protect themselves, and the best way to protect themselves is being in front of those things.
Absolutely, Jeff. I mean, the firms, more than anything, firms hate surprises. So if they get a complaint letter a month or 6 weeks later from this customer, and they find out that that the advisor had a disquieting phone call with that client, 6 weeks ago, and didn't say anything to management, that's not going to put the advisor in a great light with the firm.
Yeah, it's interesting how it's sometimes it's not the end, it's not the event itself, it's the way the event gets handled, right? And that's that can create more damage than the initial event.
Absolutely. That's absolutely right, Jeff.
Yeah. Hey, Scott, this has been great information, great insights, and I know our listeners will get a lot of valuable information out of this. Thanks again for your time today.
My pleasure. Thank you. Have a good day.